Hi, my name is Stephanie Perotti. We're going to talk a little bit about licensing today, but first I wanted to give you a little bit of my background. So I am currently the Interim Executive Director of the Fabric Foundation, but I started my career in the music business working for Universal Music. Fast forward a little bit, I worked for Hot Topic headquarters. That was my introduction into licensing, and my first memory of getting involved in licensing was actually attending a screening of Harry Potter before the final edits were made, looking for ideas for creating licensed product. So from there, we got involved in a lot of licensing, and Hot Topic is one of the industry leaders in licensing today. Fast forward a little bit more, I worked for Band Merch doing license and entertainment property merchandising, and from there, I actually went to work with Jonathan and Drew Scott from Property Brothers, building out their Scott Living brand. From there, I went to Frank Lloyd Wright Foundation and had the privilege and honor of managing Mr. Wright's intellectual property catalog, which was quite vast. And today, I'm here to talk to you about licensing. So getting started, we want to talk about protecting your work, your creative work that you've developed, and trademarking. So what we want to do initially is trademark what you have created so that you can monetize it in different ways. So the things that you can trademark are your name, logo, and slogan. Other things you can do are copywriting, and copywriting applies to original, literary, dramatic, musical, and artistic works. So copywriting is a protection that generally lasts 70 years. There's always some exceptions to every rule. There's a lot of exceptions in copywriting. A work for hire is a copyright that persists for 120 years after its creation or 95 years after its publication, whichever is shorter. So works created before 1978, copyright duration rules are more complex, and that involves a lot more legal study that we're not going to get into today. But it's also good to know that a patent applies to an invention or a tangible idea. So we're talking about technical processes, machines, manufactured goods, chemical formulas. There's a utility patent and there's a design patent. So a utility patent generally protects the way an article is used and works, and it usually lasts around 20 years. A design patent talks about how something looks. So utility is how it works, design is how it looks. A trade secret applies to a practice or a process that's not known outside of a company. So the fact that it is a secret makes it special, and that's what we're protecting with trade secrets. So why should you trademark? It's important to show that you have ownership of your intellectual property, and that's why we need to trademark things. So we're showing a presumption of validity and ownership. So this is important if you have to deal with an infringement case, and it also makes it effective for you to police your brand in multiple ways, especially with an Amazon brand registry. So you have to have something trademarked in order to get into that process to protect your brand. And it also deters folks who have similar branding from doing something too similar to what you're doing. So what is similarity? Similarity is very subjective, and there's a lot of subjectivity around the legal component of this, because what's confusing to you may not be confusing to me, and vice versa. So what is confusingly similar and what is substantially similar? Again, kind of subjective. So it's really about preventing consumer confusion. So if there's the possibility of creating confusion in the marketplace, this is what we want to stop from happening. So the USPTO, the trademark office, they're there to make sure that this kind of stuff doesn't happen. So if two marks are too similar and there's no control, then that's when we get into legal problems. So the owner that holds the earliest use and trademark for the right is left to defend the mark. But it's important that you show a beginning time frame for use. So what do we go through? What process do we go through to actually trademark something? So you can do it yourself. You can do it on LegalZoom. You'll be dealing with the USPTO. It takes about 3 to 6 months. And again, it's really important to note the first date of use. And you actually have to trademark by country. It's much easier and much cheaper to do it that way than getting global trademarks. So USPTO, what tools do they have? They have a trademark search system, and they have a document retrieval system. So these are two things that you can access. So what symbols do we need to use, and when do we need to use them? So using the R symbol, little circle with the R in it, we want to only use that after federal registration. So you have to have applied for it, and you have to have received the trademark registration from the U.S. government. Very important. So using it without that can actually get you denied for your trademark application. So the TM and the SM symbols, the trademark are for things like goods and clothing, and a service mark is for things like consulting. So you can use both of these before you file a trademark application or during the process. You won't get in trouble for that. So let's talk a little bit about intellectual property law. So we'll go through the basics, and then I'll give you some resources to use. So the basics, we want to talk about patents. So a patent provides the inventor a legal right to protect your invention, be it a product, design, or process related to fashion designs is one use for them. And by securing a patent on a novel invention, the inventor can safeguard their intellectual property. So some examples of this again is from the fashion world, but technology used to manufacture Crocs shoes, that's proprietary, wrinkle-free fabrics, UV filtering textiles, fire and water repellent textiles. So there's a specific technology used to create these things, therefore you can patent them. And what you can do with your patent once you own it is license it, and we'll talk about that. So an artistic creation cannot be patented, very important to know. So then you want to go back and look at copyright, right? So fashion designers usually don't opt to protect under patent law for a variety of reasons. Again, a lot of legalese that we won't get into today. But more expensive and time-consuming to obtain a patent than a copyright or a trademark. So trademark law protects a business's commercial identity or brand by discouraging other businesses from adopting a name or logo that is confusingly similar. Again, we're talking about what's confusing and to whom, so there's some subjectivity to this. Confusingly similar to an existing trademark. And trademarks are the most widely used means by which fashion brands, creative brands in general, protect themselves in the U.S. So why doesn't copyright law apply to fashion in the United States? And we're using a lot of fashion references again because this applies to quite a few different types of creative businesses. So separability is a prerequisite for a garment or other useful article to be protected by U.S. copyright law. So that is, can you take certain components out of it and still use it in the way which it was intended, and can you tell what the thing is that you designed, or taking pieces out of it going to change the functionality of it or the recognition of it. So in the European Union, they have a lot of more history to their fashion industry than the U.S. And that also applies to a lot of other industries as well, again, because we're looking at creative industries. So the EU has registered and unregistered community design rights protected to protect garments and accessories as a whole. So we have France pioneering designs back in the 1600s, so we have a lot more history to work with there. So that if you're looking for case studies, this is a good place to look. So unsuccessful proposed changes to U.S. copyright laws. There have been a lot of attempts to make changes to this in the States. It's generally just not a lot of movement in that area. So some legal precedent. This is a good case to look at, again, if you're looking for some precedent to go back and reference for legal purposes. So the Supreme Court actually clarified standards for separability. It's really, again, about protecting the original design and noting use of that design. So can you protect something like a single color? And this is an interesting case study. So the Lanham Act, and there are two actually cases to go back and look at if you want to learn a little bit more about that, the Christian Louboutin case and the YSL case from 2008 and 2011. So again, this is Louboutin talking about the red sole. Can they trademark the red sole? That's what a lot of people consider a huge part of that brand. So are they able to protect that? And that's what that case is about. So another thing to talk about is trade dress. So trade dress usually refers to product packaging. And the courts recently extended the definition to be an essential component of a design of fashion apparel. So if you have a creative business and you're packaging it in a certain way, trade dress can be considered a big part of that. So Adidas, we have the 3 stripes, Burberry, and their particular tartan plaid. These are things that have been so closely associated with these brands that is considered part of their trade dress. So let's talk a little bit about licensing fundamentals and what we can do within the licensing industry to monetize the intellectual property that we just talked about protecting in various ways. And the reason you want to protect it is so that you can monetize it. So what is licensing? So licensing, generally speaking, is when an IP owner, you're then considered the licensor, has granted another party, which we consider the licensee, the use of their IP in exchange for something, usually money, but it could be other considerations. If someone who could be a licensor doesn't have a license to use intellectual property, it's considered infringement. So why should you license? So as a licensor, as an intellectual property owner, high return, minimal risk. So basically, you're not, as the licensor, taking a lot of financial risk to create product, to test things in the marketplace, to go through the product development process. That risk usually falls to the licensee. And you're reducing the cost of product development, you're maximizing your brand exposure, you have another alternative revenue source from however else you're monetizing your brand. And from a distribution standpoint, you have different retailers in different territories that you can get into because you have a relationship with a licensee. So a licensee, why would you want to actually participate in licensing as a manufacturer? You would increase your credibility in the marketplace by associating yourself with a high recognition brand. You have a lower cost of going to market than if you're building a brand from scratch. And you would increase the appeal to retail buyers. So being associated with a brand that's being licensed to you might get you in front of a buyer that might not otherwise talk to you, or get you into a retailer that might not otherwise talk to you. And it gives the smaller companies the ability to compete against larger companies. So again, we're just looking at a larger presence in the marketplace as a manufacturer, as a licensee. So where did licensing come from? We want to figure out what the precedent was for all this stuff that we're about to talk about. We'll look at some early occurrences in the industry, but we'll start in the Middle Ages. So the churches actually endorsed tax collectors to give them credibility with the people from whom they were collecting tax. So they were able to identify themselves as being associated with the church in a significant way, which gave them more credibility. So some early pioneers beyond the Middle Ages, we'll go into the 1800s. Bush was the first product that was actually licensed, was a wine key. So we're looking at a corkscrew, a bottle opener, that type of thing. And the manufacturer of the wine keys actually realized that if they put the Bush logo on the wine keys, they might sell more. So Bush makes some money, they sell more wine keys, everybody's happy. And we can go into some different industries now. Now this is merchandising. Now we'll talk about publishing. So Beatrix Potter wrote Peter Rabbit, and she actually had she owns that IP, right? She protected herself. She had a publishing deal that she struck up in 1902 to publish her story in a broader and more meaningful way. We can look at the New York Herald. There was a cartoonist for the New York Herald who drew Buster Brown. And they actually licensed Buster Brown to Brown Shoe Company in 1904, sold more shoes, New York Herald makes a little money, everybody's happy. So you've probably heard of teddy bears. Where that came from was actually a story about Theodore Roosevelt, who went bear hunting and actually wasn't very fruitful in his bear hunt that day, but did come across an older bear towards the end of the day and actually asked the guide to put him out of his misery. And that story about how Teddy Roosevelt was sympathetic to the bear got a lot of press attention. So the Ideal Novelty Toy Company actually contacted Teddy Roosevelt and said they wanted to make bears and call them teddy bears to commemorate that story. So the royalties from that program actually supported national parks. So here we have the first instance of a nonprofit benefiting from a licensing deal. And then we can talk about the Girl Scouts, who have applied their name through various licensing relationships to over 1,800 products by 1912. So let's look at some trailblazers in the industry. We can go back to 1932 when Disney actually hired Kay Kamen, who's considered the father of modern licensing. And his strategic approach to licensing, very important, still applies today, is that licensing is meant to be mutually beneficial. So the manufacturer, the licensee, benefits because they're selling more product. The licensor benefits for all of the reasons that we talked about, but also monetary benefits. So by 1935, so we have 3 years here, from when he's hired to 1935, more than 1,000 products were made using Disney IP. And even in the middle of the Depression, the General Foods folks paid $1 million to Disney to be able to have a Mickey Mouse cutout on the back of a box. Another instance of Disney's success is actually helping Ingersoll Waterbury out of bankruptcy. And through a watch deal at Macy's in New York, they sold 11,000 watches in one day. And now we have, in 2019, Disney Consumer Products selling $54.7 billion, and they consistently rank in the top 3 of consumer products in the licensing world. So we have another industry trailblazer, Frank Lloyd Wright, who actually launched his own licensing program in 1955. So he ran that program himself for 4 years. Started out with the things that were most closely associated with his work, home goods, so rugs, paint, furniture. And there was actually, in November of 1955, an entire issue of House Beautiful magazine that was dedicated to Frank Lloyd Wright and the launch of his products. So another thing to note about Frank Lloyd Wright is that he had fellows working alongside him most of his life, and the things that they created were considered work for hire. So this is important if you're in a creative industry and you're working for another entity. Do you own the work that you create while you're working for them? That's something you need to make sure of before you go down the road of trying to secure trademarks, copyrights, things like that to do with the work that you create, because your employer most likely owns that work. So in the case of Frank Lloyd Wright, the fellows created designs, surface designs, lots of different designs, architectural designs. The Frank Lloyd Wright estate owns all of that. So two different ways to use the work. We can use it very literally. You can take a surface design, print it on something flat, sell it. That's the easiest way that you can use something that's a creative design. So that's good for giftables, t-shirts, prints, things like that. Replica pieces, anything that's created in a model format, furniture, things like that, you can replicate that. That's a pretty literal translation. One arena you can play with there is modifying the size. So for instance, with the Frank Lloyd Wright chair, you can buy a miniature version of it, you can buy a life-size version of it, and now you can buy an actual kid-size version of it. And another use is inspired by. So rather than taking something, like we said, surface design, putting on something flat, selling it, you can take an element, a design element, and make a repeat pattern out of that. Or you can take the philosophy with which something was designed, apply it to something else, and that can still be considered part of the portfolio and can still be branded that way. So there's a lot of different ways you can play with the intellectual property. So this is an example of a program that I put together for the Frank Lloyd Wright Foundation with Crate and Barrel and a company called Epicurean. So obviously Frank Lloyd Wright didn't create dinnerware in his time and kitchenware, but we can take the designs from different things that he's created and use them for another purpose. So another trailblazer in the industry, we're going back to 1977 here with the first Star Wars movie. I could spend 3 hours just talking about Star Wars, but we won't go that deep into it. I'll just highly recommend that if you're interested in licensing or toys or Star Wars, that you take a look at this documentary, The Toys That Made Us. It's the first season, first episode, and it's on Netflix. Highly recommended. Very cool thing to watch. And I put this image on here because I think it's so interesting. They couldn't keep up with production. Initially, they weren't expecting Star Wars to be such a success. So because they couldn't come out with the product soon enough for the holidays, they actually made this early bird certificate package so that you could redeem at a later date for the actual products. And I was lucky enough to have one of those when I was a kid. So that was the beginning of my career in licensing, I guess. So different types of licensing. We have technology and patent licensing, software licensing. I'm sure you've bought software in your lifetime and you had to enter a key, that type of thing. So you've licensed that software from the actual person who created it or company that created it. There's trademark licensing, character licensing. When you start getting into a lot of overseas licensing, especially in China, most of the licensing you see there will be character licensing. We have brand licensing, and then we have ancillary product licensing, which is more commonly referred to as merchandising. So let's talk about types of licensees and types of licensors. There can be lots of entities that participate in this. Types of licensees are manufacturers. So that could be someone who is already manufacturing something and wants to utilize a different creative or a different brand on the product. We can also talk about retailers. So that's called DTR, direct to retail. That's where someone who owns a brand, a licensor, would work directly with a retailer, and the retailer then secures a manufacturer to produce the products specifically for that retailer. And then there's companies like brand agencies. So these are generally the three big ones that you'll hear about in licensing news. But Iconics owns these brands. PVH owns Calvin Klein and Tommy Hilfiger. And then we have ABG that owns things like Sports Illustrated, Barney's, Forever 21. So the different types of licensors, those can be corporations. We talked about Girl Scouts earlier. Those can be artists who own the rights to their work and want to license it for different purposes. We have inventors who can patent something and then license that technology to a manufacturer. And we have the estates. Those are generally, dead celebrities kind of fall in that category. So the estate of that person who then owns all the intellectual property of the person who originally created it can license that out. And then there's agencies that work on behalf of a creative entity or a brand to secure licensing deals for them. So the top three global licensors, and these, you won't see a lot of change in these as the years go by, but generally we have Disney, Warner Brothers, and Marvel always topping the entertainment charts, and then we have these folks, and you'll recognize all the ones in sports, so all the jerseys, all the hats, all the things that you see, the products and the merchandise created, those fall into the sports categories. So something as a licensee that you should be asking about your prospective licensors, does that licensor own and control the IP? I could go up to you and say, I want to license Mickey Mouse to you. That doesn't give me any right to do it, right? So we need to make sure that whoever you're talking to actually owns that IP. Are they legally protected for those categories? So you're going to trademark things by product category. You can't produce things outside of those categories that you have the rights to without securing the rights to them first. So the relevance of the brand really should be at the top, because this is what's most important. You have to understand that the reason we would want to put a brand on something is because that product would be more marketable with the brand on it. If no one knows what that brand is, then there's really, the value of the license is very low. If it's a highly recognized brand, the value of the license is going to be higher. So just because something isn't currently relevant doesn't mean it's not going to be relevant, let's say in a year, or be more relevant in a year. If a movie's coming out, if you go to the licensing expo in Vegas, virtually or physically, You'll see a bunch of movie properties that haven't come out yet, but there's a lot of hype around them, and that's why these licensing deals are being signed on the floor. The audience. Does the audience align with an audience that you're used to talking to? If not, maybe that's not a good fit for you. What's the marketing and promotion support that the licensor is going to provide? Is the onus of the marketing going to be on you as a licensee, or is the licensor going to help you actually promote your products? So what is the brand integrity? Are they spreading themselves too thin? Is the brand getting into categories that are going to affect the brand integrity currently or in the future? We want to know what other competition is in the market. Is there similar IP? Are we doing something that has already been done in some way? Is it going to be less compelling when you release that product? Digital brand assets. So this was really important, especially going back to the Frank Lloyd Wright example. When I started with the Frank Lloyd Wright Foundation, we had a ton of things that had been designed but hadn't been digitized. So they had to be recreated in order to use them in a digital capacity. So what has already been done and what needs to be done, and what as a licensee is going to fall on you to do, that's very important. And what's the approval process? So this can be really simple, can be really difficult. Some entities require 3, 4, 5 layers of approvals, and it could take a year or 2 years to get something approved. That's going to drastically change your go-to-market approach, so it's really important that you understand that. So as a licensor, what should you be asking prospective licensees? So what is the desired brand positioning for the manufacturer, for the licensee? Is this meant to be a collaboration? Do they want brand transparency? Or is this more like a white label situation where the manufacturer, the licensee, wouldn't be known to the end consumer? That's something it's really important to address that up front. What existing retail relationships does the licensee already have? Is this licensee perhaps in a retailer that you want to be in, and that's why you're seeking out this deal? If they don't have any retail relationships, how are they going to distribute and market and sell your products? So is that licensee able to drop ship? This is important too. If they just don't have the capability to drop ship, then you're taking yourself out of a lot of potential channels. So a lot of retailers at this point will not necessarily want to take inventory. They'll want the licensee to be able to drop ship once an order is placed. So that reduces the retailer risk. Very important to understand up front if this licensee can actually fulfill something like that. Also important when dealing with Amazon, and lots of other companies are doing drop shipping nowadays. What's the financial health of the company? This is important too. Can this entity afford to pay you your royalties? This is something that you need to know. And so do your homework there. Dun & Bradstreet is a good reference for that. And you just want to make sure that there's no lawsuits pending. And some of that can be addressed in the licensee questionnaire and application before you get into deeper discussions. What other licenses does this entity hold? Are you competing with something too similar to what you're doing? Or have they only taken licenses that are very different from yours, which could be a bad thing because they won't necessarily know how to manage your license? And what's the motivation behind the seeking out of this license? So it's important to understand that if the licensee just wants your license to have in their portfolio to give them credibility, but are going to get their foot in the door, perhaps with a retailer or with a buyer, is that their motivation behind getting the license purely to sell their own product, which they wouldn't have to pay you royalty on? Is that the reason behind it? So I've actually had a licensee tell me out loud that that's the only reason they wanted the license, is to get their foot in the door. Are they active in their requested territories? Just because a licensee wants a global license doesn't mean they should have one. If they want to get into Japan and start pushing their own product in Japan and know that your brand is relevant in Japan, Are they just using you for that purpose? On the opposite side of that, do they want global rights to something and they only have distribution in the United States? And then you're giving away territory and probably not going to get a lot of sales in those territories. Follow through, very important. So this is something you should be able to suss out during the initial part of your relationship. Is this prospective licensee able to follow up on requests quickly? Know that this is something that you're going to have to deal with on an ongoing basis. So you want to notice those habits and see if there are any red flags there with follow through at the very beginning. So are there expectations grounded in reality? If you have a licensee that has a if we build it they will come mentality, it's probably not going to work out. Just because you produce product doesn't mean you have an audience for it, doesn't mean you have retail for it, and it still has to be marketed. So there needs to be some level setting with expectations before you get into a relationship. Does this licensee play well with others? You're probably at some point going to have your licensees work together at a retailer or in some kind of synergistic way to put together a larger program. If they're not playing well with the other licensees, it's going to be problematic. Do you want to deal with that? Is it worth it? This is a question you have to ask. So types of properties. These are generally, when you're talking about licensing deals, these are the categories that the properties fall into. So within those product categories, we have these categories and subcategories. Again, these are just kind of industry standards. You can download this presentation and have reference to that. So Contracts 101, let's talk about what's going to happen once you decide you want to do business with a licensor or a licensee, what happens next. So some things that you need to know from a terminology standpoint. The term is the full duration of the contract. And you want to be careful about this. If you're really approaching this relationship as testing the waters, you don't want to get into a 5-year, 10-year commitment. Maybe a 1-year, 2-year term would make more sense. Contract periods can be months or years. Generally, the contract periods are important when you're talking about when a product is going to be launched, because sometimes it takes 18 months to 2 years to actually launch your first product. So you would want to, as you're negotiating the contract, make sure that the royalty, the guaranteed minimum guarantees and the royalty payments, you're not obligated as a licensee to pay a high minimum guarantee in an initial contract period when there's no product in the market. So something to be cautious of there. Net sales, very important in the contract negotiation to understand what net sales are. So net sales are gross sales minus deductions. And what those deductions are very important because that can make or break you. If you, as the licensor, allow your licensee to too many deductions, the net sales can go down pretty low, and then you're getting a royalty on the net sales that are whereas you could have been getting them on gross sales, but you've allowed all these deductions, so you're making a lot less money. The royalty rate is the percentage of gross or net sales. There are categories. There's a lot of things published that talks about what categories and what ranges fall into what categories. Licensing International is a good resource for that. So if you just Google Licensing International, that's the trade organization that publishes a lot of information around that. Minimum guarantee, very important. The payment due to the licensee regardless of sales. So if you commit to a high minimum guarantee as a licensee, you're going to owe that money regardless of whether you sell 0 products, 1 product, 10,000 products. So be very careful when you're talking about your minimum guarantees. An exclusive license and a non-exclusive license. So an exclusive license is worth more because you have exclusivity either in a category of product or in a specific geographic area, or it could be specific to a sales channel. So you could say, I have exclusivity for online sales, or I have exclusivity for museum sales, something really specific like that. So the licensor generally has to understand the value of that and understand that there's going to be a significant advertising spend or marketing commitment associated with getting that exclusive license. And if there's a non-exclusive license being discussed, there needs to be an understanding of why you're getting a non-exclusive license, because you could have someone else, another manufacturer, another licensee, creating very similar product to what you're selling and thus competing with you in the retail marketplace. So applications and agreements, these are just some types of contracts that just know these are going to be part of the process when you're entering into a licensing deal. So if you're starting out as a licensor, you can sign a deal with a licensing agency to represent your brand. And you would want to do this for a couple of reasons. One, if you don't want to handle that in-house, if you don't have the bandwidth, the capability in-house to do that. You'd also want to use a licensing agency if they have a portfolio of brands that are aligned with yours in a significant way, to make deals easier to get. A sub-agent agreement would be something in which a licensing agency or your in-house team is then using an agent to do specific deals. So sub-agent agreements, everybody's going to get a piece of the pie, so the more people you have involved, the less money you'll get at the end of the day. Licensing applications, so as a licensor, if a licensee wants to do business with you, they'll have to fill out a licensee application, giving you a little bit of background on their business, why they want the license, can they handle it. That's something that you need to take care of up front. So a deal memo basically extracts the key points from the deal, so you can look at all of those without going through a 10, 20, 30-page contract. Deal memos are generally 1 or 2 pages. You negotiate on those deal points, and then you go into long-form contract. A licensing agreement would be that long-form contract, and then a manufacturer's representative agreement. If, as a licensee, you have someone who is representing your company, like a sales agent, that deals specifically with a particular retailer, a category of retailer, that's a manufacturer's representative agreement. And as a licensor, you want to know who's representing your brand in the marketplace, so you want to identify that up front. So some resources for you. This, again, is going to be on the deck if you download it. Licensing International, again, the trade organization that all things licensing are involved in. License Global is a great magazine, as well as an online newsletter that you can get with updates about licensing deals, industry information. LegalZoom will help you through all the trademark and copyright issues. And then we have Fashion Law, which is, again, great case studies for creative industry situations. And then the Intellectual Property Organization has any kind of legal updates around IP. So if you have any questions, feel free to connect with me on LinkedIn or email me or call or text me, and I'd be happy to have licensing discussions with you. Hope this helps you as you start your journey into licensing. Now, go start something.